Welcome. Today's Wednesday, November the 17th. Women's Canadian Club of Hamilton is gathered again to have a very informative presentation with our guests. I am Louise Noel Ambrose, the president of the Women's Canadian Club of Hamilton, and we thank you for being here. Thank you for your patience. We recognize and acknowledge that we are gathered on the traditional territories of the Mississauga and the Haudenosaunee nations, and within the lands protected by the Dish with One Spoon, Wampum Agreement. Might we not only learn about the Indigenous people of Canada, but from them. The WCCH is striving to continue to be a group of people concerned about issues that affect women, educating and advocating for those issues in our community. The purpose of the Women's Canadian Club of Hamilton is to foster throughout the Greater Hamilton area an interest in all matters of public concern, to strengthen Canadian unity and identity, encourage the education and promotion of Canadian history and heritage, foster an appreciation of Canadian culture and traditions to new Canadians. And we meet monthly, the third Wednesday of each month via Zoom due to the current circumstances. And we have featured speakers on a variety of social issues. Today, we're speaking on, our guest will be speaking on estate planning, administration, and litigation with Shana Bixma. I'm going to read a short bio of her. Called to the Ontario Bar in 2012, Shana articled and practiced with firms in Toronto and Burlington before opening Bixma Law in 2018 here in Hamilton. A passionate innovator and entrepreneur, Shana's practice focused primarily on estate law, which is litigation, administration, and planning, and also incorporates corporate and real estate law into her practice. Shana was the 2019, 2020, and 2021 Platinum Award winner for the Best Lawyer and Best Real Estate Lawyer in Hamilton, while her law firm, Bixma Law, was voted the 2019, 2020, and 2021 Platinum Award winner for Best Law Firm and Best Real Estate Law Firm by the readers of the Hamilton Spectator. So indeed, we have someone with knowledge and great advice to provide to us today. A foodie at heart, you can often find Shana enjoying a coffee and a treat at one of Hamilton's fabulous independent coffee shops. I'm not sure if that's happening much now, but I've known to have the opportunity to do that with her. Let us welcome Shana to our group today. Welcome. Please, you have the floor.
Thank you very much, Louise, for that kind introduction. And thank you to you all for having me today and for the little rounds of applause I'm seeing. Thank you. So I'm just going to share my screen here. I do have some slides to get through that will just guide the discussion. And if you have any questions for me, it may be easiest if we save them till the end. But otherwise, you can put them in the chat and we'll get to them then. Okay, so one moment here. Let me just get that started. Oops, you're probably seeing the wrong screen now. One moment here. Are you still seeing the regular PowerPoint screen? Bear with me one moment.
I'm seeing the crime we compete against our family.
Yes, but are you seeing the slides on the left-hand side as well? Or are you seeing?
Correct.
Okay,
Yes.
Then I just have to stop the share and do it on the other screen. So okay. Thank you. That's one. There you go. Are we seeing the complete screen now?
Correct.
Excellent. Thank you, ladies. All right. And I see there's a gentleman here, so thank you to the gentleman as well. Okay, folks, a little bit of a different twist on estate law that you may not be expecting, a bit of a metaphorical interplay with criminal law in terms of the crime that we commit against our family. And this crime, in a nutshell, is either a complete lack of planning or failure to update your existing plans to reflect your current circumstances and your current wishes. So either way, a failure to plan or to get a plan in place at all is effectively akin to a crime that we commit against our family, because we leave them with an unnecessary financial burden and time-oriented burden if there's any court involvement that's needed to rectify a problem that you could have addressed with proper planning at the outset. So that is the main message that I'm hammering home to you all today is, if you do not already have a will and powers of attorney in place, you need to get that done ASAP, and our firm is happy to assist you with that. And if you are among those who have an existing will and powers of attorney, but maybe you haven't looked at them in 10 years, 20 years, or longer, or especially since any circumstances may have changed, such as, divorce, a new marriage, death of anybody named in there, or just the falling out of a relationship, let alone if you've had a significant increase in your assets since you last did your will, then time is now to be revisiting that and getting everything updated. So that's the nuts and bolts of what will guide this presentation. First of all, a bit about me. We always like to learn a bit about our speakers, right? So I am a mom, a proud wife, friend, entrepreneur, but most importantly, a mother of two wonderful little boys. And we have a third little person on the way, gender to be revealed at the time of birth, which is estimated to be early February. So I am in that stage of life that I take it many of you were in, not in a too far, distance in the past, where you are at that initial juncture where many people think of doing their wills and powers of attorney. You have children, you've bought a house, maybe you're on your second house, you have a business. So you do that initial step of getting your documents in tow then. So these are my little guys. That's my husband on the left. And this photo dates back to about Easter of this year. And also about me, we love to travel pre-COVID, of course. Traveling in the time of COVID, I think, is a whole other beast from what I hear with all the tests required. But our favorite destination by far has been Scotland. I'm not sure if there's anybody here who is of either Scottish ancestry or who has traveled out there, but it is stunning. My background is from Jamaica. I'm an island girl in the Caribbean, and I love sunshine and beaches year round. But I was astounded at the beauty in Scotland. We've been back twice, and our firm is actually structured in a non-traditional way. Even though we are based in Hamilton and we have an office there, our services are provided about 98% remotely, as long as the client has access to Zoom and is comfortable with using, DocuSign to sign documents and otherwise email, then really only about 2% of the time do we have to provide in-person services. So that has freed us up on, a personal, professional note to continue working wherever we have great internet. And we spent over a month the last time working in Scotland, and just logging in on using the internet at our Airbnbs and traveling throughout, much of that beautiful country. So doing conference calls or presentations like this or court hearings with a beautiful view of a quaint Scottish village right in front of me out the window. So that's a bit about us and what we enjoy, and a bit about me. So now on to the, the fun part of our presentation. So what are the ramifications for not planning appropriately? And when I'm speaking about planning, I'm speaking about getting a plan in place. So getting your will and powers of attorney in place to begin with, or updating your plan as your circumstances have changed. Either is considered, for the purpose of this presentation, a failure to plan. Okay, So as you can see on the left, it says convicted of not being prepared, AKA your failure to plan. What happens here? What's your worst case scenario? Well, there are a few things. Number one, a family feud could erupt and cause even more issues and money. When I see this all the time in terms of my estate litigation practice, folks who pass away without a will, first of all, so that's your absolute worst case scenario. Well, now it's a free-for-all in some ways, in terms of anybody can apply to be your executor. But it's not a free-for-all in terms of who gets your estate. If you die without a will, then the first $350,000 out of your estate goes to your legally married spouse. That may be fine if you're in a happy marriage. That doesn't work if you're in a common law relationship, because common law is excluded from that. A common law partner gets nothing from your estate if you die without a will. So keep that in mind. If they're not jointly on any asset that you own, so if they don't have joint ownership of any assets, such as a house, if they're not jointly on bank accounts, etc., then you're leaving them in the dust if you have no will. Legally married spouses, as I mentioned, get the first $350,000 out of your estate, and then the balance, if any, goes to an equal split between your legally married spouse and any surviving children that you have. So as you can see, your spouse gets the lion's share for the average estate that may be modest and under $1 million in terms of total value. And your children get a much smaller portion. Is that what you want? Maybe, maybe not, you know? And the other thing to think about that often catches people, there are many folks, you know, in the empty nester retiree age who are separated from their spouses, but not actually divorced. They have moved on to a common law relationship. They have been separated from their legally married spouse for 20, 30 years, just never got around to tidying it up with a formal decree of divorce because, you know, you've moved on, you're amicable, your kids are grown, and you didn't want to go through the expense of getting that final divorce order. That will come back to haunt you if you were to predecease that legally married spouse, because guess what? Remember, common law doesn't kick in at all. Marriage does, even though you've been separated from that spouse for decades. Suddenly, he or she can come right back in if you predecease them and get that first $350K out of your estate. They're legally entitled to that, and split the remainder with any children that you have. So for many people, that's a very unnerving thought. All the more reason that if you do not have a will yet, get it in place, because you want to have control over who gets your estate, and you don't want to be falling to the default of the Ontario laws on this issue. Now, for those who may not have a legally married spouse and don't have any children, you're thinking, well, you know, does the government get my estate? Not quite yet. The government only gets it if you have absolutely no next of kin left. So no children, no parents alive, no siblings alive, no cousins, no aunts or uncles. They go through the whole family tree before the government gets anything. But think about that. You may have relatives there as we go along that list that you may not necessarily want to get your estate because you haven't talked to them in decades. Well, all the more reason to have a will. And then if you don't have an updated will, then you run into similar problems, though not the same. You have a valid will, so it's going to be distributed in accordance with your valid will. But your wishes may have changed, especially if you haven't updated your will in 10, 20, 30 years. And another thing that tends to catch people is marriage. So you may have an old will from when you were perhaps recently split from your ex, if you are on a second marriage now. But if you haven't updated your will since then, marriage voids existing wills. Many people don't know that, unless you made that will with specific language in it that says that it is in contemplation of marriage, and that marriage had to have happened within a year of when you did that will. If none of that happened, then guess what? You're sitting on a will that isn't valid, and you're back to the situation of someone who has died without a will. So all of these touch points that people don't often think about triggering the need to have a will or a need to have an updated will. I want to flag those for you so that you can park those in your mind. And if you are one of those that falls into any of those categories, please get in touch with us. We can help you get that rectified ASAP. And if you get in touch with us soon, get it done before Christmas. Wouldn't that be nice to have that load off your back, knowing that you've updated your estate planning and you have that peace of mind going into the new year that everything's taken care of? All right, so we've already gone through a bit of this so that your assets will be divided according to the law, not your wishes. As well, if you die without a will, there's more money out of the pocket of your loved ones. So without a will, there may be some additional court orders that are needed to cover things that your will would have covered, because executors can't act. And some of you may have been executors, for other people's estates, in terms of a carte blanche, perspective, without authorization from a will or authorization from a court. So if there are specific things that an executor has to decide about in terms of management, like can the executor rent out your home rather than sell it right now in the current market? If your will doesn't address that, they're going to need a court order, and that's expense. Anytime you have to get the court involved, that's thousands of dollars, sometimes tens of thousands of dollars out of pocket to get the court order on that, especially if it's contested. If you have a beneficiary that objects to the executor wanting to do that. That's why you want all those things to be clear in your will. Get a properly done will or a properly updated will so that it is clear what the executor can and cannot do. And then that way you avoid the need for court orders because there's clarity. Okay. And then, of course, you can be leaving someone out of your estate, the third point that you had planned to include. Whoops. And guess what? They don't just get in there otherwise. They are out of luck. So think about that. Another thing, because particularly since it's a mostly empty nester retiree group in the room today, some of you may have some pets. You can include what's known as a pets trust in terms of the care for your pet animal if you were to predecease that animal, because we know that animal bills are, medical bills at least, are no joke. And so if you wanted to leave aside a portion of your estate, some people may leave aside $10,000, $20,000, some leave aside more to cover the financial burden for anybody that may have to take over the care of that animal. And if that animal requires any surgeries or treatment, you can include that in your will. So while your pet is property under Ontario law, your pet still, should have a place that way in terms of ensuring that you're not leaving that burden on somebody else who then drops them off, at the SPCA or anything like that, okay? Or at a shelter. Now, powers of attorney. This is an often overlooked document. I get a question from a lot of folks. Do I really need a power of attorney? I know I need a will, but do I really need a power of attorney? Yes, you do. And this is why. And this is actually the busiest area for estate litigation right now, has to do with powers of attorney, especially given the over 65 crowd. Why? Because if you don't have a power of attorney in place, then a court-appointed guardian of your property and a court-appointed guardian of your person is needed. Remember what I said earlier. If you involve the courts, that equals expense. And guess what? Who pays that expense? Up front, it's the person that's seeking to be appointed. So that could be a spouse, that could be an adult child, that could be a niece or nephew who's an adult as well. Anybody. It's a free-for-all at that point, whoever wants to apply to be your guardian. But they could be shelling out $10,000 or more to do that because they need 2 capacity assessments, which can run about $1,000 a piece. And for each appointment, that can be up to $4,000 just to get the necessary documentary evidence for that application. And then you have the legal fees on top of that to prepare all the materials and present it to the court. And then if it's contested by somebody, you can see that costs go up exponentially. Versus, for instance, at our firm, the cost to get your POAs done, powers of attorney, both of them, is $250 plus HST. unless they're included in an existing package and it goes down to 200. So look at that disparity in numbers. It makes no sense to not have valid powers of attorney in place versus the financial burden you're putting on somebody who seeks to apply for that position to the court. And then you wonder, well, what about the government? Well, the public guardian and trustee will only agree, because they have the power to refuse. The public guardian and trustee will only agree to be your guardian if nobody else is available. And they will only do it for property. They never do it for the person. So you still need somebody else to make those decisions for you. And next of kin isn't always acceptable by hospitals, long-term care institutions, especially if there's a conflict between next of kin. Then you see those institutions will back off and say, we're not acting unless there is a guardian appointed. So do you see what a mess that is? That could be solved so simply with having these two documents in place. Otherwise, you're looking at protracted power of attorney litigation in the courts. And so you want to make sure it's done properly so that you can minimize the chance or even eliminate the chance of that happening. If anybody's disgruntled, you can shut it down easily and quickly because you have valid documents in place. And I don't think I mentioned this previously, but remember that extensive legal bill that you're looking at. If you don't have powers of attorney in place that somebody has to fork out, they have to find that out of their own money. They can be reimbursed after they're appointed from your funds, but you're putting that financial burden on a loved one of having to come up with $10,000 or more out of their savings, out of a line of credit, whatever the case may be, just to fund this. That's probably not something you want to be putting on a loved one when you are already in a position where you cannot make these decisions for yourself. So they're grieving the loss of your ability to make those decisions. And so the loss of you as a person in many ways. And now you're slapping them with a big financial burden short term to even be able to deal with your affairs. Don't do that. Okay. So as we start to look at getting closer to wrapping up, how do you break the proverbial chains here? Okay, using the criminal law metaphor. So as you see under the first tab, decision, we have a quote from Walt Disney. The way to get started is to quit talking and begin doing. Procrastination is the most common thing I see with clients when it comes to estate planning, and I get it. Especially with younger folks who think that, look, I'm not going to die or become incapacitated anytime soon. I got time. But at any age, you may even think that, look, at whatever age you're in your 60s, you're in your 70s, you're still pretty healthy. You got some time to deal with this. You never know what can happen. And as you can see, hopefully by the examples I provided to you already, some of these situations can strike you without warning. And I'm sure you all have friends or family who have suffered a sudden, critical illness that may have landed them in the ICU, that may have taken their lives, that may have left them, quite debilitated. A stroke, for instance, can do that quite easily. Don't take that risk. Get your affairs updated, get them done, get them even in place if you're one of those who doesn't have any of these documents, so that you do not leave that burden on your family. Because sometimes I hear from folks, well, what do I care if I'm dead? It's not my problem. But wow, that's not a nice thing to think about in terms of your loved ones. Now you're leaving them with stress, grief, and undue financial hardship. That was completely unnecessary. Number 2, hiring a lawyer. Make sure that the lawyer has the right experience. Okay, as Luis mentioned at the outset, estate law is my primary area of practice, and I've been at it for 10 years come next June, so 9.5 years at this point. Don't go with somebody who only dabbles in estate law. I do see many poorly prepared wills that come across my desk for litigation. Literal 1 or 2 pagers that don't even touch on the main aspects that are critically important, that weren't properly witnessed, all those things that make it easy for me as a litigation lawyer to challenge it and get it declared to be invalid by a court. Don't make that easy on somebody. Hire a lawyer who knows what they're doing, who has extensive experience in estate law. That way you can be assured that your documents are done properly the first time or this time. One thing that our firm is noted for is that we communicate well and regularly. That has led us to, wonderful glowing reviews by clients and lots of votes, in our community and among our clients for, say, things like Reader's Choice. We communicate well and regularly. You're not left wondering what's going on with your file. And we also use technology to improve your experience. As I mentioned before, about 98% of our services are provided remotely using technology. Most people want that nowadays. Most people have been forced to become comfortable, for better or for worse, with Zoom, email, electronic signatures. So we can do that. And for those that are not comfortable, then you're in the 2% that we can meet with at our office and get the job done in person. So where possible, we try to improve the user experience so that you can be where you are right now. I see some of you look like you're in your living room, you're in your kitchen, right? You don't have to leave your house to come and meet with me or a member of my team to get your estate planning done. You can do it from the comfort of your own home. Number 3, planning. If you've decided that you are one of those that needs to update your plan or even get your plan in place, start thinking about the major categories that need to be covered. Choosing who your estate trustees are, that's the modern term for executors. Primary and an alternate person for each category. Who you want to be your attorney for property and your attorney for personal care. Those may be different persons because you may look at the loved ones in your life and think some of them are financially savvy. Others, or maybe this person's financially savvy. Another person may be great at taking care of your medical decisions. The two may not be the same person. That's okay. Think about people who can work together, because oftentimes if one power of attorney has to be invoked because you're incapacitated, the other may also have to be invoked. So make sure that these people can work well together. Maybe there are 2 adult children of yours who can work well. All right. And also ensure that you've accounted for all of your assets. You don't have to go into a nitpicky detail about, rings and necklaces that you have that you want to give to, so-and-so, unless you want to. But just think about where you have, your savings, what real estate property you may own, if anything, such as your current house, and make sure that you know where everything is. Also, it's a good time to, if you haven't already, get your, if you still have life insurance and if you still qualify for it at your stage in life, then speak with your life insurance specialist to make sure that your beneficiaries are up to date. Otherwise, ensure that your RSPs or your RIFs, your RRIFs, are up to date with your beneficiaries. Ensure that if you have a pension, your beneficiaries are updated on there. And ensure that if you have any tax-free savings accounts, your beneficiaries are also updated on there, okay? So make sure that while you're thinking about your will, that you're covering all those other areas that are also equally relevant if you pass away. Everything's up to date and you have peace of mind. And you can get this all done before Christmas if you were to choose us to handle your will and powers of attorney. So that way you, again, peace of mind is what you want. You don't want any guessing games that cause stress. Okay, if you have any minor, I would say not children in this case with the crowd we have here, but grandchildren. Some of you may have minor grandchildren or great grandchildren or minor great nieces or nephews who may be beneficiaries of your will or under your will. So maybe you're going to want to think of any graduated trusts is a term that we use for those. Maybe you don't want them getting their full share of your estate at 18. I think if we all think back to when we were 18, we may have been quite responsible or not very responsible. It depends on one's life experience at that age. So you may prefer that any minor beneficiaries of your estate not get everything, even if it's only $10,000 or $20,000 or less. You probably don't want that money dropping into their laps at 18. Maybe you want it to go to them at 21 or 25. You can do things like that in your will. And so that you delay them getting money from your estate until they're a bit more responsible to handle it. All right. And then a family disaster clause, that's number 4 under planning. That comes in terms of if all your proverbial beneficiaries went down with the plane, everybody was traveling on a plane post-COVID to a family reunion, let's say in Jamaica at a resort, and everybody's on the beach having fun. But then, God forbid, the plane goes down. Who is your backup beneficiary that is not immediate family? Not your adult kids, not your grandkids, if you have any, not your spouse. So give that some thought as well as to maybe you have extended family that you wouldn't normally be traveling with for something like that, a vacation or whatnot. Maybe there's a charity or 2 or 10 that you'd like to leave your estate to. Things like that you want to keep in mind. Proper estate planning ensures that you do not have a void in your will, because a void, a gap, if everybody passes away or nobody wants the share, means that the court has to get involved to determine who gets your estate. Remember, court involvement equals expense. So plan properly and you avoid that. Okay, under signing, we have here that we aim to have all of your estate planning documents done and ready for signing within 30 days from your monetary retainer being paid. And at this time of year, that would equal to getting it done before Christmas, as an example. So, and I would even stress further, you're probably thinking 30 days, okay, that's a lot of time. That allows our firm to be able to get through all the files needed in a time-effective manner. But time investment on your end is low. You're not spending 30 days thinking about this as a client. Your time investment is no more than 3 hours in total, including the signing meeting. That accounts for taking the time to fill out our initial questionnaire and hop on a phone call or video call, as the case may be, or an in-person meeting if needed, to go over your estate planning wishes, and then reviewing the draft documents and approving them. It can be under 3 hours of your time. Who doesn't have 3 hours of their time in the next 30 days to get their wills and powers of attorney in place, or get their wills and powers of attorney updated if you need either of those things to be done? We can find that time, okay? That's less than 1 hour a week. You can do it. So don't let time be a reason for procrastinating. And as I mentioned before, peace of mind. Now that you have your estate planning completed, you are given a pardon for ensuring that your family will not pay for your crime of not being prepared. So with that, I conclude, and hopefully I've hammered this home to you all today. Failing to prepare is setting your family and friends up to fail. Therefore, take the steps to break the cuffs of procrastination and set your family up to simply grieve the insurmountable loss of you and not have a heavy financial burden, let alone a litigation burden in terms of court cases regarding your estate that could have been avoided almost entirely or completely entirely, depending on the case, with proper planning. My contact info is there. I believe it was also circulated in the promotions for today's meeting. We can see my email address there and our website. And I don't see our phone number there. So for those who prefer a phone number, if you have a pen, it is 905-522-1234. Yes, it's an easy number to remember. 522-1234. I'm at extension 1. You can leave a message if you don't get me, and we'd be happy to take this burden off your shoulders. Thank you all so very much for your rapt attention to this presentation. Thank you again for inviting me to speak today, Louise. And let me know if I can answer any questions that you may have.
Before we open for Q&A, I'll ask Lee Gowers to give a word of thank you, please, to Shana.
Uh-oh. Okay, sorry, couldn't find the mute button. Shana, I just want to start by saying I loved your comments about Scotland. Our youngest son had the great privilege of living there with his girlfriend for 2 years on a travel work visa. And try as we might, we didn't get over to visit them. Just when we actually thought we might get there, of course, the pandemic hit, and that put an end to that. So anyway, we're hoping that post-COVID we can get them together and go back over. And apparently he knows all the good pubs to drink at, so he'll be a great tour.
That is key. That is key. Wonderful. I do hope that he gets to go over there. It is just a stunning country, even on a rainy day. It's stunning.
Oh yes, yeah. He would send us pictures and videos, and it was great. But I do want to thank you for coming today and to addressing the members of the Women's Canadian Club on this very, very important issue. I've been dealing with estates and powers of attorney and wills and everything for the past 2 years. I don't recommend it as a pastime, that's for sure. But I have learned the importance of just what you said, of planning ahead and having things in order, and for heaven's sakes, review that will that you've set aside 30 years ago when the children were 2 years old and needed a guardian, because now they're 32 and they sort of take offense at that kind of thing. So, so I think all your points were very well put and very pertinent, and we should all really pay a lot of attention. And I hope that we all, get our heads around this and think about it tonight. And if we haven't done all these things or reviewed these things recently, that you've showed us how important it is to do that. So it was a tremendous presentation, very well put, very easy to understand. And we do thank you very much for coming and sharing your expertise today.
Wonderful. Thank you all for having me. Appreciate it.
Lee.
Thank you.
Any questions? If you could raise your hand. Judy?
Okay, Pat, you have to unmute yourself if you want to speak. I've muted everybody to avoid the dog and phone thing. Pat, there should be a thing that looks like a microphone in the bottom left-hand corner of your screen. You just have to click on that to get the X off it.
Very good. Okay,
There you go.
there I am. Okay, I've lost my question. Just give me a minute to reorganize here. I guess it's just a question around only the people that are named in the will can be power of attorney. No one else can act on your behalf. Is that correct?
So you're conflating two documents here. So only the persons who are named in your powers of attorney. So typically it's about two persons named in your power of attorney for property, and typically two persons named in your power of attorney for personal care, but it can be more, it can be fewer. Only those named persons can act in those roles. Similarly, in your will, only your named executors can act in those roles. Now, the deviation from that can happen if any of those persons either is unable to act because they've predeceased you, or they're not mentally capable because they're ill or whatnot, or they may resign or renounce at the outset, say, I don't want to touch this. I don't want to be your power of attorney. I don't want to be your executor. Then there can be a gap if there's no alternate person that is named in the document to step in. Then there can be a gap and a bit of a free-for-all at that point, which requires a court appointment. Remember, court equals expense. So yes, anybody that's listed in the document, until they are no longer able to act in that role because they resign, renounce, die before you, or are mentally incapable of acting, they are the only ones that can act in those roles. If there's no void created by their absence for any of those reasons, then they are the only ones that can act.
Thank you.
You're welcome, Pat. Thank you for that question. Anybody else? I see Ellen.
Ellen,
Yeah.
Unmute.
you're muted, Ellen.
You're muted,
Oh.
yeah.
There, okay.
There you go.
I want to say thank you as well. It was extremely interesting. Over the summer months, our lawyer who prepared all our papers for years retired, and he has sent the files to another lawyer who we've never met. Now, if we decide we don't want them to be with her and we would rather come to you, what do we do?
Yes, you can just get in touch with our office. We actually don't need to see the former, the existing wills that you have, unless you'd like us to see it for ease of reference in terms of names that may still be included in your new will or powers of attorney. But otherwise, you can just simply contact our office and we can get your new file opened and get your new will done. We don't, I make it a big part of my practice to not do codicils, which are amendments to wills, because then it can be a pain to track if there's ever any litigation or if you have to administer that estate. What codicil, what amendment is the last one? Whereas it's easier to track, believe it or not, with a full will that's done. So yes, so you don't have to worry about necessarily getting the file from that new lawyer who you've never really met or spoken to, and then bringing that to our office. If you have it, great, but we don't require it. We can get started without it if you know the information offhand that you can put in the questionnaire for us as to who fills what role.
We do have copies. Now, I hope you don't think this next question is rude, but in the case you were on maternity leave, what happens?
We have a junior lawyer And so there's a junior lawyer that's there and my 2 clerks. And I'm still on. I'm not on because of being a business owner, you don't get much of a maternity leave. So I'm still available. Thank God so far. My last 2 births were complication free. And, you could say rightly or wrongly because of that, I was back at work 3 days after having my second. But at least on a court conference call and whatnot, and doing work mostly remotely until, you're fully recovered from childbirth about a month, 6 weeks later. But yes, I have a junior lawyer who's wonderful. She works closely with me, so she can stand in for me if anything needs to, like she can take instructions for the will, she can do signing meetings and whatnot. And then otherwise, I'm still around. But the goal is at the first 30 days after giving birth. So that is due date is January 31st. So, give or take until the beginning of March. I will try to have February be quite slow for me. So if you'd like to get your estate planning done by, I would say, mid-January, then for sure, touch wood, I shouldn't have gone into early labor by then, and we can definitely have handled that, and you can have me on it. Otherwise, like I said, my associate Hortense is fantastic, and she can definitely carry things in my stead if it cannot otherwise wait till March.
Well, we wish you all the best with your new baby.
Thank you. Thank you very much.
Who we don't know the sex till you announce it.
Yes, yes.
So I'm praying everything goes well.
Thank you, Ellen. I really appreciate that. And I'm sure for you all are probably guessing, just like my family, because with 2 boys, the question is, will it be a 3rd boy or will we get a princess? That is the $1 million question. So we'll definitely keep you posted through Louise, and I'm sure she'd be happy to share that news with you once baby arrives, God willing, safe and sound.
Wonderful.
Thank you, Ellen. Hey, I see your hand up. Yes.
Thank you. I was just wondering, the person who is named as the executor in one's will, if by chance this person does no longer want to or cannot act in this responsible role, can the law firm then become the executor of one's will?
Not unless they are named. And it wouldn't be a law firm, it'd be a person. So it would be like a lawyer, for instance, that agrees to act. Like if I were to agree to act, for instance, as your alternate executor, then I would have to be named in the will. So that's the importance, if you remember near the end of the presentation, in terms of a checklist, right? Who you want to be thinking about, your primary and alternate. Remember that point? That's so key. So you have your primary and you have your alternate. Sometimes you may have a second alternate rather. So a 3rd person lined up. If you think that, your first alternate, so your second appointee, may not be able to act, right? So you need to have somebody listed in the will. It's not a default assumption that your lawyer, say myself, can automatically then become your executor without the court appointing me. I would need a court appointment for that.
So just to recap there is no one else who I want to be the executor. There is no one else who wants to be it. There's no one able to do it. So a person from the law firm has already been named as executor.
Yeah.
Let's say that person who is named from that law firm is no longer with that law firm. How does that work?
It's the person. It follows the person, not the law firm.
So
for instance, it's Shayna Beeksma as an example. The firm isn't even referenced in that appointment. In the alternative, if Louise Noel Ambrose has predeceased me, is unable or unwilling to act, then I appoint Shayna Beeksma as my alternate estate trustee in the stead of Louise Noel Ambrose as an example. So then it doesn't matter where Shayna Beeksma is, as an example. Shayna Beeksma could be, maybe have folded her practice. There are 0 plans for that, by the way. I'm continuing this thing for the next 20 or 30 years. I have 0 plans on becoming an employee. I love being my own boss. But let's say, for argument's sake, Shayna Beeksma has folded her practice and is now with the city of Hamilton. that doesn't stop me from acting as that alternate executor because my employment post has changed, because it follows the person, not the position.
Okay, thank you.
You're welcome. And another opportunity as well, in terms of if you have nobody else to list, they're expensive, but you can retain all the banks. All the big banks have a trust company arm of them, so they can act as an institutional estate trustee. The fees are hefty, so they often don't make sense for estates that have assets less than $1 million in total, just because of how high the fees are. But if you have, I mean, in this market, you know, and a house on the West Mountain that's mortgage free could easily be that, right? Or more. So if you have an estate that could be sizable if liquidated, and you don't have anybody else that you want to name as your executor, then, for instance, you have your CIBC Trust Company, Scotiabank, all of them have one. You may consider appointing an institutional estate trustee to handle it, and then the fees make more sense. It certainly doesn't make sense for smaller estates.
Wilhelmina had a question.
I have one.
Yes,
Hi.
I was really surprised that when you were saying that we have to include our animals.
You don't have to, but it's advisable if you don't want to leave a significant medical bill with a loved one.
Yeah, and that's a great idea, because I would never have thought of that.
Mhm, mhm.
So I'll have to get that all fixed up for my animals with my son and grandchildren.
Yeah, no, that's wise planning. You save them having the headache, right, of being hit with significant medical bills for your pets, because they know that you loved your pets and that you wanted to, you know, have them continue to care for them. The last thing you want is to leave them with a nasty bill that they have to foot on their own or take out of their own inheritance out of your estate. If you've set aside money, it makes it easier.
Yeah, because that was one thing I never ever thought of.
Yeah, and you're not alone. Many, I would venture to say most folks were not aware of that. So all the different aspects of planning, that's why it's so important, you know, to speak with an estate's lawyer and to get that done, because it's worth it in every way, shape, or form. Even if I wasn't doing estate law, I would still be preaching till the cows come home. Meet with somebody who knows what they're doing in this field and know your options. Know your options for planning properly, saving your loved ones a headache, and realizing the options that you have available for making sure that wishes that you didn't even realize that you had can be affected in these documents. There's definitely a gaping hole in the knowledge in our society, as with many things. I mean, I'm not a general contractor. You ask me about stuff to do, you know, to my office or to my house, I won't know. So there's such value in speaking with someone who can advise you properly on all your options, so that you know that your wishes, you know, are being taken care of and they will be implemented after you die.
Yep. And I traveled all over Scotland.
Oh, so you know how beautiful a country and wonderful people they are.
Oh, yes.
Oh, yes.
My
You know,
late
they were lovely.
My late husband came from Glasgow.
Okay, a Glaswegian.
Yeah.
With a very thick accent that can be very hard to discern at times.
Yeah.
I remember having to lip read some of the Glaswegians. I was thinking, holy cow, that is a thick accent. Edinburgh was easier to understand, and even up in the north and the islands, but yes.
I know, because people used to ask me, how come you understand us? And I look at them, because I'm married to one.
Yep. Your next badge of honor would have been understanding Gaelic. If you understood Gaelic, then I mean, yeah.
Yeah.
Amazing, amazing. Thank you for sharing that. Thank you, Wilhelmina.
You're
Any
welcome.
questions?
Thank you.
I have a, yeah.
Also, yeah.
Go ahead, Alison.
Thank you. I have I have a comment which has been solved, but I just wonder why it happened. When we were dealing with my mother's will 3 years ago, it was from 1987 and everything was fine, except the lawyer and the witness, who was his secretary, had signed it. And for some unknown reason, we had to have proof that the person that signed it was who they said they were. So thankfully, due to Facebook, we just Googled the name and came up with a nephew in Toronto. We sent a picture of her signature and he said, oh yeah, that was my aunt. So that was solved. But how did this happen?
Well, it sounds as if you may have been missing what's called the affidavit of execution, because that's a key document that accompanies your will. And so we do that for our estate planning client. The necessity of it arises because of probate. So as part of the probate application, which most estates need probate, and I didn't even get into what that is. So if you'd like me to explain that for anybody in the room, I'm happy to. But in a quick nutshell, probate is a court's authorization of the last will of the deceased as being indeed the last will, or appointing someone as the executor in lieu of a will if there's no will. So to apply for probate, if you have a will, you need to include at least one original affidavit of execution, which basically says that this person, they sign it. So say that lawyer, for instance, or his or her assistant who witnessed it, signs it saying that I, Shayna Beeksma, witnessed the will signing of this Schedule A appended will of Allison Buffett on November 17, 2021, in the presence of, Lee Gowers, and here to affix my signature. Okay, so that's kind of the rough wording in the affidavit of execution, but the court requires that as proof. You only need one, you don't need both. We prepare both anyway, as needed, but you need one for probate. And if you don't have that, then you go on that bit of a, I guess a rabbit trail, like you described in terms of trying to track down proof for the court, because they would have needed an application to the court then, that the signature on the will of this witness is indeed the same as the usual signature of that witness, even though they're no longer available, presumably deceased, for instance, right? So you couldn't track them down, because otherwise what I've had to do in the past in those situations where one of those files has landed in my lap for administration, of course, meaning helping the executor wrap up the estate, then I've had to track down, okay, that lawyer is deceased, but maybe the assistant is still alive. I found the assistant working at another firm. It was a Hamilton firm that did it. Now that assistant is in Burlington. Track down that assistant and get them to sign an affidavit of execution, because there wasn't one with the will. And that was the case that we had 2 years ago, where we followed the will and power of attorney file to the new lawyer that took over that deceased lawyer's practice. But that new lawyer didn't have an affidavit of execution, and we couldn't get probate without it. So that's how you can get on that bit of a rabbit trail, to just track that down, get it for the court. That's why it's required. Yeah. So if you come to us, we help you avoid that. You get your affidavit of execution right away, and it goes with your file. Okay. So you don't have to worry about that. Yeah. Okay.
Well, that was 40 years old, the will, too. So that might have made some.
That can be tough. Yeah. And then you're tracking things down more. And yeah. And the unfortunate thing is that some firms, we don't do this, but some firms charge you extra to do the affidavit of execution. So watch for that.
Yeah. Okay. Thank you.
You're welcome.
Susan?
Oh, I just wanted to mention, does anyone remember the Hemsley people in the States owned a chain of hotels and were not nice people? Anyway, when talking about animals, it reminded me of that. When she passed away in her will, she had that her dog or cat, I think it was a dog, got $1 million for his care after death. I'd like to know who looked after him, because wouldn't they get the $1 million?
Well, I mean, that's an interesting thing. I mean, it's a trust. Hopefully there was an additional clause in the will that stated, to the extent that this money is not used up on the animal, then what happens to the excess? Maybe it goes to remaining beneficiaries or whatnot. You don't know. It depends on what the will says. Or there was a hoity-toity, Hollywood vet that charged, I don't know, $500,000 each for the surgery, and the dog had 2 surgeries, and whoop-de-doo. But somebody got that money, that's for sure.
Mary, you have to unmute.
We're not hearing you, Mary.
She's trying. Mary, it's the icon in the bottom left that looks like a microphone. It should have a red
Okay, sorry.
thing across it.
Yeah,
Hello, Mary.
hello.
We're hearing you now. Oh, I'm not sure which Mary is. Mary Lorimer, I
No,
guess.
it's Lorimer, Mary Lorimer.
And Norma
Okay, that's not me.
Okay, sorry, wrong Mary.
Oh, there
Didn't
she
know.
is.
There she is
Apologies.
now.
Does
You
that
got-
help any?
Yeah, we
Yes,
got you now,
Yes.
Mary.
Yeah, okay.
go ahead.
I still can't face the camera. No, I can't
Don't
get my
worry, we
face
can
going
see
that
you.
way. Anyway, I just I don't think this was suggested at all, but I have currently 3 executors. They are not ranked. You found a problem with that kind of situation?
They're not ranked. They're all
And then
equal.
there are, Joe and Sally and whatever are my executors.
Yes, and they're all at the same level. It's not like Doug is
Yes.
your
Yeah,
primary,
they're all-
Sally's
that's
lieutenant.
right. I mean, the reason that I've gone that way is that each of them brought different talent to the table.
Yeah. And that's a common reason, especially if they're your adult children that I see,
Yeah.
we know with some of our clients. It can be a problem of too many cooks spoil the broth. The fundamental issue, Mary, is whether they work well together.
Yeah.
If they cannot work
We're
well
going to
together,
find out.
yeah. If they cannot work well together, then it's going to be a problem
Yeah.
in the administration.
I can
process.
understand that. Yeah. Okay.
Yeah, but the nice thing is that nobody is strong-armed into acting as an executor, as I mentioned. If, at the time of your passing, all 3 have survived you. If one of them decides, I don't want to handle this, then they can renounce right at the outset and leave it to their 2
I'm already
siblings.
hearing little echoes of that as we age,
Yeah.
because my executors have aged as well as I have, and don't quite see it as as simple a job as it was 10 years ago. But,
And it's not a simple job, honestly.
No.
It is a very thankless job. That's why many people may think, initially, unless they've acted in that situation already, oh, it's an honor that somebody has wanted to name me as an executor. Well, yeah, it's an honor, but it's a pain in the rear, as I think we, implied earlier, right? It's a thankless job, and not many people want to do it.
I may
So,
have to make some changes yet, just
Yeah.
to let them be free.
Yeah, if that's what they want, because if you already know that they're going to renounce or resign at the outset, then it's
Yeah.
wise to update it so that you're not left with a void.
Right.
I see Pat has her hand up there.
Can you be paid to be an executor?
Yes, right. At law,
Oh, yeah.
actually, you are entitled to compensation, estate trustee's compensation. It's not a grand amount. It works out to be roughly 5% of the estate when all's said and done. And it breaks down to like 1.5% on receipts, roughly 1.5% on disbursements. There's a whole formula that breaks down. And at the end of the day, if it's challenged by a beneficiary or more, the court will take a look at, the actual amount of time that you've had to spend as an executor administering that person's estate. Was it complex? Was it simple? There are lots of factors that go into that. But at the end of the day, the estate trustee or executor is entitled to be compensated for, their pains, is what the case law says, the pains and efforts involved in being an estate trustee or executor. So now you can cap that, you can put in limits in your will if you don't want it to be the default at law, like I said, which totals roughly 5% of your estate. You can, reduce that in your will, but that's roughly the default that in most cases will be awarded, give or take a bit. Similarly, your powers of attorney, so the persons that are your attorneys for property and personal care, they too are entitled to a small degree of compensation, not much. Most people peg it at around minimum wage, although you can certainly increase it. But at a minimum, and you can ask that in your powers of attorney. You can say that they are not entitled to compensation, but at a minimum, folks are entitled to be reimbursed. For sure, if they're acting in any of these roles, they're entitled to reimbursement. You can't exclude that from them in any of those documents. Any other questions?
I have a question. I'm not sure we're hearing background noise from somebody. I'm not sure who. I had actually two questions, Shane, and they have to do with, well, I guess trustees mostly, or executors, whatever you want to call them. My understanding was at one time that if you were making up a will in the province of Ontario, that your executors should also be resident in province. And I'm wondering if, given that, I mean, you can go to Scotland and do your work from there, is that rule still applicable today, with the advances in technology and that?
Yes, so what that has to do is with the administration bond. So because whenever you're applying for probate, if there's a will, then part of the probate application is that on a standard basis, we ask the court to waive the requirement that the executor post that bond. That bond is equivalent to double the size of the estate. So most people don't have that kind of money sitting around. There are a few insurance companies that provide bonds, but you're having to apply to them. They're looking at your credit worthiness. And then there's a premium that will be paid, typically a one-time premium for the bond, and it is an estate expense. So the idea behind the executor residing in Ontario is to avoid the need for that bond. If there's a will, so note to self, if there's no will, the court will almost always require a bond. Okay, that's another expense you don't want to have to, and hassle you don't want to have to leave on somebody's head that's a loved one. But if there is a will and the estate trustee or executor is not living in Ontario, then the court will be concerned about waiving that bond on the application for probate. And they're concerned because of the protection, the need for protecting the beneficiaries. If that person is not resident in Ontario, that person could make off with the estate's money and have no seizable assets in Ontario, be very hard to track, and good luck to the beneficiaries getting the money that person has made off with. That's why the court requires a bond to be posted, whether it's an insurance bond or the person forking out the money and paying it into court, which, like I said, is typically in the six figures when you're looking at double the value of somebody's estate, and to protect the beneficiary. So it's less where the person is, say, working, for instance, like Lee, like you mentioned, I've worked in Scotland for a month easily, but all my assets are here in Ontario, and I'm an Ontario resident. That didn't affect my residency status. So that would have zero effect, even given the advances in technology on the court's rationale, if I'm seeking to be appointed as the estate trustee under somebody's will. It's if my assets are in another jurisdiction and I'm not resident in Ontario, then courts get concerned, and it's up to the discretion of the judge. Typically, it's an over-the-counter application at that point. It's not a hearing, but typically the courts will be concerned about waiving the bond, where it would be hard to enforce against you if you turn out to be, a criminal, estate trustee who misappropriates funds out of the estate. That's their concern. So that's why I still recommend, where possible, focus on picking persons who are resident in Ontario, back up being resident in Canada, avoid those who are resident overseas and have no Canadian assets. Otherwise, just know that they will have to post a bond, and they may just have to go through that process of applying to an insurance company to get a bond policy.
Thank you.
I think you had another question as well, Lee. I think you said you had two.
No, I don't think so. I was just going to mention, having gone through all this, and my mom and dad had wills drawn up, I don't know how long ago, but I wasn't really pleased with them, because what they did was they appointed my sister and I, well, of course, they appointed each other, and then my sister and I, but they appointed my sister and I, not jointly and severally. So everywhere I went and everything I had to do, I had to be handcuffed to her to drag her along to sign paperwork and all that. And it was really a nuisance, to say the very least. So I don't know what your feelings are about that, but as the executors and the powers of attorney, I really don't like that word "and."
Well, and that's understandable. Just keep in mind that there's no option for joint and several appointment in wills. It's only present for powers of attorney. So as soon as you appoint two or more persons at one level, as, say, for instance, I'm appointing Lee and Louise as my executors and estate trustees for my estate, followed by, in the alternative, should both Lee and Louise, predeceased mayor, be unwilling or unable to act, then I appoint Kay Lumsden as my alternate. So let's use that as an example. Lee, that means that you and Louise are handcuffed together as my executors under my will.
Okay.
I did have the option at law to appoint you jointly and severally because it doesn't exist for wills.
Oh,
But if this were my powers of one of my powers of attorney, yes, you can appoint jointly and severally. And for those that may not be aware, jointly and severally versus jointly. Jointly and severally means that the multiple appointees for that position in your powers of attorney, either power of attorney for property or personal care, they have the option of making decisions together or individually. So there's no requirement of having to effectively have multiple signatures on documents. It's at the discretion of the third party that's requiring signatures and instructions, but there's no legal basis for them to compel everybody's signatures on that document. But in a will, keep that in mind. If you have multiple children that you want to appoint as your executors and you want to appoint them all because you don't want to hurt any feelings, you want them all to feel included and whatnot, guess what? They are going to be shackled to each other. Now, in today's day and age, on a practical basis, I can tell you from the estate administration perspective. So again, where I walk through with executors, I handle the legal work involved with winding up the estate. But you're at the whim of them. Some financial institutions, some third parties will be fine with one signature of the two, for instance, or three that are appointed as executors, but not all. Many of them will still require all three. So you are putting your executors at the mercy of whoever the third party is that they have to deal with in terms of whether all of them, have to be involved. I mean, in today's day and age, with a lot of things being done remotely, it's actually not too inconvenient often these days. A lot of times they can do DocuSign. I'm seeing a lot of the banks are accepting electronic signatures. But for those that don't, again, it's a chance you take, then you're forcing people to have to arrange for wet signatures to be sent or in-person attendances to happen, and that can be a pain. So it's another reason I tend to recommend to clients, if at all possible, for your will, avoid multiple appointees at one level for that reason. Make them alternates. Just designate one person. To heck with hurt feelings, you have to make a decision that's the best call for your estate, and then appoint others singularly as backups if need be. Anybody else? Does that answer your question, Lee?
Yes, it does. Thank you very much.
You're welcome. I love all the questions. Thank you all. It's nice. It also shows, engagement, that you weren't bored to tears, because I try to make it as interesting as possible, because otherwise estate law can be, a very dry area. But I'm glad for the engagement, that it all resonated with you ladies. So thank you.
Thank you, thank you, thank you. It is 2:10 p.m. We have come to an end to this wonderful, informative session. As we know, it's recorded and will be shared and also be on our website.
Madam President, are we only dealing with our speaker today? We're not dealing with any points of interest or items of interest?
No, just as always, as we have done, is our speaker. Then I follow up after with upcoming events. Was there something you'd like to add, Pat?
Yes,
Well, I can exit, Pat, if you'd like to discuss some, particular group discussion.
No, they're not legal. There are two newspaper articles that appeared. Actually, it's the same article. It appeared first in the Spectator and then in the Mountain News by the same reporter. And it's the City Committee of the Status of Women changes their name and their mandate. And I guess I was just interested in knowing whether we're interested in knowing more about the status of women. And the second item has to deal with today's newspaper article, when the mayor refers to hoping that a woman will be appointed to the police service board. Apparently there are no women counselors prepared or able to run for that position. And those, I think, are items that we should be interested in. both as a member of the police service, and the other is the Status of Women Committee.
Oh, certainly, and which will be added on the agenda for our next board meeting.
Oh,
So
is that how
certainly.
it works? That's great. That's
Go
what
ahead,
we wanted.
Lee.
Sorry,
Yes.
Pat, can I just ask a question? Were you not a member of the Police Services Board?
I was the first woman to chair the board.
Yes, I thought that, and I heard on the news last night the mayor saying he was resigning as chair and he hoped that a woman might be appointed and that they had never had a woman. And I thought, well, pretty darn sure our Pat Saunders was chair of the board.
Well, but he's referring to a female counselor. See, they get to nominate 3 from the present council. And that's what he's referring to.
Okay,
I'm
okay.
sure he knows that I was the chair.
Well, he should.
Yeah, I'll let him know. No, I was just as happy not to see my name in print. Thank you, but I thank you, Louise, for clarifying that. I suspected that maybe we will have a speaker for our membership as we did today, and all the questions will be related to the speaker's information, which it was, and it was a great meeting. Thank you very much.
You're welcome, Pat. Not a problem. All right. Our next scheduled meeting for all membership is the one we will look forward to every year, our annual holiday social via Zoom. Do practice your wonderful voices. And it's scheduled for December the 15th. Do know we are open for membership. Do encourage your friends, family members, entrepreneurs, your neighbors to become members of the WCCH. We have a wonderful website that Lee has facilitated in rebuilding. Please, if you have not had the moment to view it, please take a moment and let us know what you think about it. We're on Facebook, we're on Instagram and Twitter. If you have accounts, please, better yet, get an account just so that you can follow us and share information with your friends, family, and loved ones. Thank you, one and all, for being here today. And we look forward to your continued support. Thank you.